Hi, this is Tax Attorney Anthony Parent of Parent & Parent, the IRSMedic. In this video, I'll be discussing 6 serious defects of the IRS Streamlined Offshore Voluntary Disclosure Initiative and the one painful reality. But before we get into it, I want to give an overview to anyone who is unfamiliar with the OVDI process and some background information. The IRS has something known as universal tax jurisdiction. This means that if you are a U.S. person, by the way, a U.S. person isn't just a U.S. citizen, but also includes green card holders and foreign nationals here on a visa. Well, if you are a U.S. person, the IRS demands that you report all of your worldwide income, even if you paid taxes in your home country. And not only that, the IRS will penalize you for failing to report the existence of your offshore accounts that are over $10,000 in the aggregate. In 2009, the IRS came out with its first offshore voluntary disclosure initiative to give amnesty to those who either intentionally or unintentionally did not report income or accounts. The problem with this initiative is that the penalty structure was the same for someone who evaded taxes and someone who just made an innocent mistake. So in 2011, the IRS changed the rules by increasing penalties on those who intentionally engage in tax evasion and gave those who made an innocent mistake a chance to argue for a lower penalty by opting out of the standard penalty structure. The deadline passed for the 2011 OVDI, and now there is a rolling 2012 OVDI program. The 2012 OVDI is vastly similar to the 2011 with one notable exception. The penalties have increased again for those engaging in intentional evasion, but there is an opportunity for those who've made innocent mistakes to opt out of the standard FBAR penalty structure. Now, the area of opt-out, like mostly everything of the OVDI, is confusing. By opting out, one is not opting out of the OVDI. If you opt out, all the same protections from criminal charges are still in place. The opt-out refers to the standard penalty structure. Most importantly, opting out of the 27.5% FBAR equivalent penalty. The FBAR equivalent penalty is calculated on the highest account value in the last 8 years, or any income-producing assets where income was not reported. For instance, the FBAR equivalent penalty is calculated against rental property, even though rental property is something that you do not need to disclose on an FBAR. I told you, the rules are complicated. And I should make an important note. The 2009 OVDI only had a 6-year look back. The 2011 and 2012 have an 8-year period. To date, approximately 34,000 OVDIs have been filed from 2009 until today. Based on this number, the IRS is aware that many people have not come forward and will not come forward, which is why they are stepping up their enforcement by auditing those it suspects of having foreign accounts. The people we have seen coming forward in 2012 to take advantage of the OVDI are typically those who have made innocent or no worse than negligent mistakes. Among these clients, and understandably so, there has been intense grumblings about how the OVDI program is really unfair for people who had no idea what was going on. Not only are the lower penalties still somewhat punitive, but allow me to be blunt. Attorney and accounting fees are very real as well. The IRS claims, in response, that it created the Streamlined OVDI program. Initially, I was hopeful. This would decrease the compliance costs and penalties for so many people who did nothing all that wrong. My optimism was crushed as I started analyzing the nitty-gritty of the Streamlined program, and I found 6 serious deficiencies. First, this Streamlined program is only available to anyone who has not filed a U.S. tax return in the last 6 years. Again, if you filed a U.S. tax return, you cannot participate in the Streamlined program no matter how small your unreported tax was. This is a perverse standard, as someone who made a partial attempt at compliance is at a disadvantage to someone who made no attempt. Second, this Streamlined agreement only applies to expatriates or U.S. persons living abroad. So for the vast amount of visa holders and green card holders and dual citizens living in the U.S., this program is totally useless. This is a particularly unfair as a non-U.S. citizen U.S. person is in a worse position to know about the U.S. tax system and certainly benefited less from it than someone who is an actual citizen. Third, the Streamlined program is only available if your unreported taxes were $1,500 or less in any year. This can be unfair as well. Suppose someone had $0 in unreported taxes for 5 years and $1,501 for 1 year. Well, according to the program requirements, they would be disqualified from the Streamlined program. That is, someone who has less unreported income is treated more harshly than someone who has higher unreported income. Fourth, the vagueness. The program is only available to those who are something the IRS calls low compliance risk. But the IRS doesn't give any concrete specifics of the vast gray area between low and high. I have a good idea the lowest risk, what that would be, but as we move up the continuum, what about medium risk? And what could someone with medium risk do? At least the standard OVDI provides relief from criminal prosecution, and that makes all the compliance work worth it. But the IRS gives no such adequate protection for someone making a streamlined disclosure. Fifth, this high-risk, low-risk analysis of the Streamlined OVDI is going to give many tax professionals cover to suggest a soft disclosure. Let me get to my point. The OVDI program is really complicated, and this streamlined process just made it more complicated. And based upon how many tax professionals are advising a soft disclosure as it is, I guarantee you more of them falsely citing the Streamlined OVDI program as an authority to claim someone is a low compliance risk and thus can just blindly send in amended returns and FBARs outside the OVDI program. The IRS has warned about this, and the Department of Justice will likely be prosecuting those who attempt a soft disclosure. So let me make this clear. Low compliance risk only applies if you qualify for the Streamlined OVDI. Do not even make a risk analysis if you live in the U.S. or have already filed tax returns. This line of questioning of what your risk profile is simply does not apply to you. 6. With this streamlined initiative, there may be a perceived implication that the IRS may come out with yet another streamlined program that addresses some of the concerns I raised above. The shifting standards can convince someone to delay a decision to use the standard OVDI program because, after all, they could wish cast for a more understanding IRS. Meanwhile, the more favorable rules never come out, taxpayers get penalized to the hilt. Look, the Streamlined OVDI is fine, but it only works if you live outside the U.S., you never filed a return, and your unpaid taxes are less than $1,500 per year, and you are a low compliance risk, whatever that is. But for anyone, and I mean anyone else, who misses just one of those qualifications, if you wish to avoid criminal charges and staggering penalties if audited, and get this behind you permanently, you need to use the standard 2012 OVDI program. In conclusion, look, I understand the IRS is handing a lot of foreign account holders a raw deal. I know this is unfair, but just because it is really unfair does not mean it is not true. Right now, my firm is taking on new clients who are now under audit and have unreported foreign accounts. Sure, we'll be able to help them, but all of them wish that they accepted the painful reality and got into the standard program when they had a chance. For more information, check out my OVDI blog at IRSMedic.com or follow the link below to sign up for my 2012 OVDI Awareness Guide. This is Anthony Parent for IRS Medic. Thanks for watching.